let's just get started. Since we do have a lot that we want to get through today. So first, I'd like to welcome everyone to the LexisNexis Rule of Law panel, COVID-19 special. And today we'll be discussing the impact that COVID-19 has had on justice and the rule of law, especially in Malaysia, the Philippines, and Singapore. And we also want to understand what are some of the mitigation strategies that the lawyers in these different countries have been taking to minimize the fallout on our legal institutions. But first, I'd like to thank our esteemed speakers, Atty. Domingo, President of the Integrated Bar of the Philippines, Gregory Vijayendran, President of the Law Society of Singapore, and Steven Thiru, past President of the Malaysian Bar Council and Vice President of both the Commonwealth Lawyers Association and of Law Asia. Now, each of our guests are either current or past leaders of the legal profession in their jurisdictions, and we're very excited to hear their perspectives today. Now, for the benefit of everyone in your audience, we'll be going through 4 different topics, spending around 15 minutes each on each topic. And this includes a Q&A session at the end of each topic, as well as one at the end of the entire session. So if you do have questions, please place them in the Q&A box that's at the bottom of your screen. So you'll see 2 boxes. One is for chat and one is for Q&A. We request that your questions be put in the Q&A box so that we can manage that more easily. So just so that everyone's aware of what we'll be talking about, the 4 topics today will be number 1, the impact on lawyers and the response of the local bar associations. Number 2 is the impact on the courts. Number 3, impact on the most vulnerable in society. And number 4, impact on the rule of law generally. So without further ado, let's get started. Now, because of the pandemic, each of our 3 countries has implemented some form of a lockdown, starting with the Philippines first on the 17th of March in Manila, and then Malaysia followed almost immediately on the 18th of March, and Singapore was last to implement its circuit breaker measures on the 7th of April. So perhaps our panelists can describe the impact of both the pandemic and the lockdown on lawyers in their jurisdiction, and how has the local bar in each country responded. Perhaps, Atty. Domingo, we can start with you first because the Philippines was the first to go. Thank you. Sorry, Attorney, I think you are on mute, so you need to unmute yourself.
Good morning, Gregory. Steven, great to be with you. Hi, Hannah. Thank you for this webinar. You're correct. The Philippines was one of the first in the ASEAN region to do lockdowns, and definitely, this pandemic has impacted greatly on everyone, including lawyers. And for the Philippines, it's one of the most severe and the longest running lockdowns under so many different names in the region. And like in many other countries, court proceedings were suspended, commercial transactions, transportation was restricted, government offices were shut down, and it was a totally different environment. Now, just like anyone else, we had to grapple with the situation. And what did the Integrated Bar of the Philippines and the Filipino lawyers do? One, proactively, because we knew it was coming, the Integrated Bar of the Philippines, of course, took care of its own offices. So we advanced salaries and benefits for all our employees at the national and at the chapter levels to enable our employees to weather the lockdowns. The other one that we also did was to cooperate with different sectors to extend assistance to the frontliners, most especially. We did a lot of clarificatory bulletins and pronouncements with respect to the emergency laws vis-a-vis the rights of citizens. We are still doing a lot of information and education campaigns for our people, and also advocacies on adoption of IT so that we can proceed with the usual court processes. We have also cooperated with local government units, and the local chapters of IBP have been very innovative and resourceful in not only on legal aspects, not only in extending legal aid to the most vulnerable, but also in helping the hospital workers, health workers, and the less privileged in our country. So we have gone beyond just merely giving legal advice. At the same time, also, the Integrated Bar of the Philippines has been vocal and visible in the midst of all this confusion. And we temper the tendency sometimes of the powers that need to concentrate powers and do shortcuts. So these are many of the things that we have done, and we're very thankful. Well, not only for the National Integrated Bar of the Philippines, but for our 87 chapters all over our provinces and BCPs, and also the specialized law groups. We've also advocated in Congress and in the judicial sector key reforms. You know, this pandemic has magnified what has been apparent over the years in our country. Congested jails, slow pace of justice, and we're taking this opportunity to really push all of this. And later on, perhaps we can discuss specifics like e-filing, online courts, ADR, e-notary, and many others. But then, of course, with respect to lawyers, on a more positive note, deadlines were extended. Deadlines were extended, and it gave us more precious time to be with our families, our loved ones, and our wives. So I don't know whether or not that's positive, but definitely, in a way, the life of lawyers has slowed down, and it has, necessity breeds ingenuity, and there's so many best practices that is happening all over the Integrated Bar of the Philippines, and we hope that this is not the last of this thing. There will be others, so that perhaps across bar associations, across jurisdictions, we can share experiences so that we can better deal with this pandemic.
Thank you so much, Atty. Domingo. I mean, it's really encouraging to hear how the lawyers are not only just focused on their day-to-day work, which is giving legal advice, but also thinking about the bigger structural issues that the lawyers need to address to support society. And also, coming from Singapore, we tend to forget how big other countries can be. And if you have 87 different chapters, I'm sure that's definitely quite a challenge for the leadership to manage coherently across all the different provinces. So thank you for sharing. Steven, perhaps you would like to share next, as Malaysia came next in the lockdown schedule.
Morning, and thank you, Hannah, and good morning to fellow panelists, ladies and gentlemen. First, I want to start by paying tribute to all our frontliners in our countries for the wonderful work that they're doing, the dedication, the sacrifice, and we all have a lot to thank them for. And while we will deal with a lot of issues in this webinar, I think nothing should devalue their contributions, and nothing should be seen from what we say in any way as a criticism of what they have done. Because I think it's easy for us to be in the comfort of our offices or homes to make comments, but it is they who are in the trenches, as it were. Now, having said that, insofar as the impact of this COVID-19 outbreak has been to us, the lawyers in Malaysia, I think without being too alarmist, it has been absolutely devastating. It's caused tremendous disruption, and the financial consequences to law firms has been quite severe. Now, during the first phase, and we have had two phases now of what we call a movement control order. We initially had a full movement control order, which was really de facto a lockdown for all intents and purposes. Now we are under a conditional movement control order. But what happened in the first phase that ran between mid-March to early May, legal practice really came to a grinding halt in Malaysia. The first problem, I suppose, was because we were not classified as essential services under the regulations that were put in place. This is the Prevention and Control of Infectious Disease Regulations 2020. So that immediately made us homebound, all right? Secondly, the courts, I'll come to that later, were also not categorized as essential services, which meant the courts were not operational at all. not operational physically, except judges would go in and take on some matters, a smattering of matters on an online basis, or if it could be done by way of emails. So what we had then was a slew of adjournments of all our matters. All matters in courts were adjourned for a good part of a month, and nothing could proceed. In fact, even our land office was closed at that time. And you can imagine the problems that would cause, because when matters don't go on, all right, then lawyers can't actually bill and they can't carry on. We were all forced to work from home remotely. And you know, the new advent of online meetings for us, something that, you know, we perhaps didn't do as much as we should have. Now that became the norm. And you know, we only had at that time, and still probably, limited matters that were going on, and only urgent matters. Actually, you were just handling matters that you were already handling. Almost no new matters at all around, because of the sense of uncertainty that this has brought about, that really, you know, everything just came to a stop. Now, what it did, and I think I want to say this right at the outset, it actually has exposed some obvious shortcomings in the way we practice law. And I think we must be frank enough to accept that. Although I think the practice of law in Malaysia is fairly digitalized, but we have realized that we are still so heavily reliant on hard copy documents. And with the movement control order, you could not actually even go to your offices, obviously, to retrieve documents if you had to. So, you know, you were just locked down in your homes, documents in your office, and some documents with you, and you just can't move at all. Then there's a question of cash flow. Obviously, cash flow is severely impacted, because in as much as you are unable to work and you're relying on matters that have already been done and you issued your bills, the clients can't go into the office to process the bills where they need to do it physically. All right, and that's a real that's a real concern, that's something that you can't do anything about. Not everything can be done or approved online. So that was the first stage. And then we had the conditional MCO, which came into effect in early May. Some respite, because then we were allowed to operate, but under strict SOPs, you know, standard operating procedures, and heavy on, as you'd imagine, on health and safety. So if you were to walk into my office now, you would have to first have your temperature taken. You'd have to record the temperature in a book. You'd have to give your details. You'd have to fill in a particular form that the government requires you to fill in, to give an undertaking that, you know, you're well and you've not visited any of the places where the infection is arrived. And all this must be documented and recorded, and it's open to inspection. So at any time, if there's an inspection, and if your SOPs are found to be, your internal SOPs are found to be wanting, then you can actually have the government close you down, you know. So, and we don't operate fully. We would operate on shifts maybe, or on alternate days. So, you know, it's such a surreal environment for us, for the lawyers, in the way we operate in Malaysia. Now, the second part is the response of the Bar Council. The Bar Council has been active in engaging the courts and the authorities to mitigate the rigors of the MCO. And there's no textbook in this. You know, every day is a new thing, and every day is a new challenge. And I think quite rightly, Bar Council has placed the bread and butter issues at the forefront. And this is an ongoing thing, you know, working with authorities, finding ways to alleviate the financial hardship faced by members of the bar, highlighting aspects of the financial assistance program, which is precious little for lawyers, I must say, but, you know, trying to get what you can so that lawyers can keep their operational costs down in this time of great uncertainty. And Bar has also raised a number of questions on access to justice, and it's something that we're going to deal with later, concerning remand hearings, because you can't have persons in detention and in the continued detention and the liberty being deprived, simply because the courts can't function. And so remand hearings were then brought about in a very controlled way. Provision of legal aid has been affected because legal aid centers can't operate. And then, of course, we have the problem of the treatment of our migrant workers. So in all, I think, you know, it has been a tremendous upheaval for us. It's really turned things upside down. and the bar has also been trying to educate members to deal with this new normal of having to work from home and really being imprisoned at home and not being able to go out. So, the challenges are many and new every day. I think I'll stop with that, and happy to take questions later. Thanks, Anna.
Thank you, Steven. I think it's really interesting. As lawyers, lawyers are the gateway to justice, but a lot of the ongoing work of lawyers is really subject to sort of the market, the free market in a way. So on one hand, lawyers are private enterprises with a public role, and I think that's a very unique tension that not many professions face. So now I'd like to turn the time over to Gregory to see what Singapore has responded and what we've done here.
Thank you very much, Hannah, for the privilege of being able to say a few words in this webinar. And of course, greetings to my esteemed fellow panelists as well, whom I greatly respect, international statesmen in the bar leadership. And I think from Singapore's perspective as well, I would put this whole matter in proper perspective as an opening comment. And that is, we have to again remember that contextually, and this is probably the meta-narrative or the macro context, we're speaking about a global pandemic. That immediately frames the issue at a global level. I think our Deputy Prime Minister made the point that half of humanity is in lockdown. When you then analyze it from the perspective of the national narratives, we're dealing with, obviously public health pandemic issues at epic proportions. And this is like nothing we've ever faced before. More transmissible than SARS, certainly less lethal than SARS, but nevertheless, the kind of measures that we've all experienced here are unprecedented in our lifetime. And some have even compared the present situation to the 1929 Great Depression. So I think we need to see where we are in a sort of macro way, in a sort of global health perspective, as well as in a historical perspective. Now, having said that, I think the question for us as the bar, and I also want to echo what Steven said about the frontliners and what they're doing, and kudos to them as well. And nothing in this presentation takes away any of that frontline work and even the caregivers' work. But I think the question for us as lawyers is, how do we prevent our legal profession from becoming secondary casualties in this global crisis? And I think that's the perspective that the bar had in this matter. And that immediately then presented itself to a five-pronged strategy, which I can talk about later. But I think what I do want to focus on in response to your question, Hannah, is what did the bar do at the onset? I think Singapore at first seemingly had everything under control, and I think took very proactive steps. It was around the Chinese New Year period. And then we experienced a fresh wave of cases from what I would call the imports, the returning Singaporeans, returning residents from overseas. And that happened, shortly. We saw the spike after their return. And, that, of course, precipitated the circuit breaker phase, as we called it, which is, in other countries, it's a movement control order, you've got, shutters, you've got hunker down, lockdown. And I think one way to analyze the circuit breaker phase is really lockdown with a velvet glove. We experienced that from 7th April. And right now we are on the extended circuit breaker phase until the 1st of June. Now, what did we go through as a profession? The problem, I think the biggest problem, and I will deal with that, that the legal profession had is legal services were not classified as essential services. And that immediately caused consternation. There are limits to what you can do working from home. I think you've already heard Steven's narrative on that. But obviously, when it comes to completion for conveyancing, completion for corporate deadlines, there needs to be that physical interaction, that physical meeting that takes place. And so that actually was the biggest, problem we had to tackle. And as the bar leadership, we spent that weekend of 3rd, 4th, 5th April, which was an unforgettable memory, polling the views of the bar really across the board. We had a dedicated email address for members to send their feedback to. We contacted the committee chairs to go and speak to their members and gather the feedback and submit it to us. And I set up a task force. I had already set up a task force by that time, comprising my office bearers and myself. But our task force, because we're all litigators, lacked the corporate and conveyancing input. So I drew in the conveyancing practice chair as the leader of his bar, and I drew in a counsel colleague who is on top of his game in terms of corporate work, to make sure that we were representative and inclusive. And we looked at all the feedback that came in. And then we put out what I would call the mother of all submissions, to the government to try and make a case for why law ought to be essential services. So I'm going to now just show you, it's actually something that's available from our website, but I'm going to show you a little bit of what we shared with the government of the day in terms of the advocacy piece, because this is actually probably going to be very helpful to some of our audience as well. This is how we made the case. We said, we note legal services has not been classified as essential services, nor is the legal sector a key economic sector. We're making these representations to the Ministry of Law to put forward the Law Society's position that legal services are essential to access to justice and the rule of law. And we invited the government to give serious and due consideration to designate legal services as essential services. And I won't go through this in chapter and verse, but suffice to say that we made the case first, recognizing that we are dealing with an unprecedented problem of COVID-19. And we also tried to remind the government about the various steps we had taken to issue advisories to our members from the start of the viral episode on 29th of January, how we were trying to ensure that we didn't see clusters in our law firms and in the profession. And we gave reminders about safe distancing and so on. We then went on to make a case, and I'm happy to come back to this either later on in this session or even through Q&A, that relied or piggybacked off the fact that the courts were open. And I know there will be probably some parts that we will explore, but what the courts did as well in the course of this presentation, so I won't go through there. But suffice to say that because the courts were hearing cases, the courts were open for business, albeit hearing essential and urgent matters, we were able to rely on that to then make the case for why our lawyers needed to go in to ensure access to justice for the public. And so essentially we articulated it from the perspective of legal advice, legal guidance and advice on rights and duties for our members. We tried not to overreach by pointing out that our lawyers could go in for reasonable time-limited access to their offices with sufficient safeguards. And we also pointed out that at a time like this, with people now staying in close proximity, and as much as it's a time for spending with loved ones, and I echo what Attorney Domingo has said about that, but for some people, I'm afraid the love turns to hate and tensions rise. And we know about phenomena like corona divorces in China and Japan. We know about, the increased incidences of domestic violence. And we said, look, they need protection. They need, access to justice. And we made the case even from that point of view. And so we, in a nutshell, tried to articulate the case for essential and urgent services. And, thankfully, the government considered the representations. I have to say, we also drew from precedents elsewhere like UK, but, the government acceded to the representations. And in the event, we actually saw a recognition for areas that we had advocated, not as much as we had hoped for, but nevertheless, we did see a fair bit of recognition for the advocacy that we had rendered. And so I'm just going to screen share the 4 categories of areas that the government had recognized ultimately in response to our representations that were done on an urgent basis in that unforgettable weekend of 3rd, 4th, 5th April. So they recognized essential and urgent matters for litigation in criminal, civil, and family matters. And this was the piggyback point I made. They recognized that commercial transactions or actions having statutory, regulatory, or contractual deadlines, whether local or foreign, falling within that circuit breaker phase, for which no waiver or deferment has been or will be granted, or transactions or actions for which completion is due or time is of the essence in that period, ought to be recognized. And then a parallel category for conveyancing transactions. And last but not least, urgent and essential wills probate related services, for example, the drafting of wills and execution of lasting powers of attorney for the vulnerable as well. And I won't say more apart from saying that obviously people would be contemplating their own mortality at a time like this. People will be thinking about these aspects. So I'll stop there. Probably there's a lot more we can say, but suffice to say that the bar, I think the single biggest contribution, and I don't want to blow our own trumpet because there's an ongoing work. We're now coming out of the circuit breaker phase. We're very humbled by this whole experience. It is deeply humbling, but it's our privilege to serve. And I think this is a time when, in as much as technology needs to be safe and secure, the bar needs to provide that safety and security for its members.
Thank you very much, Gregory. I think what really stood out to me was the very collaborative approach that the legal community took in recognizing that we are facing an unprecedented situation. Lawyers are not the only ones going through this, but it's really something that's happening on a global scale. And also, because of that, recognizing that the role that lawyers play in touching in every aspect of our lives, right, from commercial to property to civil to family, that lawyers in a way support essential services even if we're not classified as essential services, and some sort of leeway needs to be given to ensure that this can continue. So thank you very much for all that sharing. I want to quickly move on to the next topic on the impact on the courts. Now, it has been mentioned that lawyers were not classified as essential services for most of these jurisdictions. And in some cases, the courts were continuing, or in some cases they had stopped, depending on what the matter is. So I wanted to hear the perspective on what was sort of the impact on the judiciary and what the judiciary did. How did they respond? I know in Singapore, there were some online hearings. In Malaysia, there was some live streaming of appeal cases. And we also heard in the Philippines that a lot of government officials were taking on technology to support with this remote working. Gregory, maybe we can just go back to you very quickly on how the courts responded when it came to this pandemic.
Thank you, Hannah. And I'm happy to kickstart this particular segment. We have to give credit where credit is due. I'm very, very impressed with the fact that our judiciary is, tech savvy. And they were able, to operate even during this circuit breaker phase. They complied also very much with the spirit of the circuit breaker phase. But notwithstanding that, I think the level of innovation and also the access to tech, I think was a very key difference. I think if we turn back the clock, 17 years ago to SARS, I don't think we would have had that level of, tech ability and also infrastructure to be able to conduct hearings. So let me just deal with, three different ways in which, the courts stood out, I think, in this time. And because they were able to allow for essential and urgent legal services, essentially that kept the litigators in business, as it were. And help them to carry on some work. Obviously, it's not the same as pre-circuit breaker, but able to generate some revenue and provide that access to justice for their clients as well. So first up, we had the state courts provide a very innovative solution which involved the use of emails for non-contentious directions. And it was impressive. It was very well received. The lawyers were briefed, and everyone saw the wisdom of this because it ensured that we don't come into unnecessary close proximity. But you could actually transact a fair amount of non-contentious directions. I mean, ideally by way of agreement. So there's obviously that's the first port of call. But where not agreed, then you put your brief submissions in by way of letter. And the courts would then, based on those emails that come in, make a ruling in terms of directions. And this worked very, very well, as you can imagine, for procedural types of matters, for directions where you don't need to really see counsel, as it were, but you still can hear counsel. Obviously, this needs to be finessed. And one suggestion that I did broach with the courts, the state courts, a number of times, it's quite open, so I can say it, was to take a leaf from Hong Kong's books. because in Hong Kong in February, Justice Coleman, in a groundbreaking decision, made orders for telephone directions to be conducted. And so you can imagine that even on the basis of email, sometimes there may be clarifications needed. Rather than postponing or inviting further letters, you could troubleshoot it by way of a telephone call. And you know, this is not new, because in the arbitration world, you see this all the time, you know, telephone directions and so on. So that was, I think, a fantastic innovation. Then at the same time, you know, our entire judiciary carried on with Zoom hearings. And very much like, you know, what we're seeing now. And I think, of course, one big difference is this is a webinar, but that is a courtroom, albeit you're in a virtual setting. And I think an important Grundnorm that needs to be observed by everyone, you know, who appear before the judges in a virtual setting like that, is to recognize the dignity and the decorum of the courtroom. But because of the ability to zoom in and zoom out, as it were, by way of these virtual court hearings, for the urgent and essential matters, so for instance, injunction hearings, discharge of injunction hearings, matters where there were deadlines, and I flashed that letter that we wrote crystallizing the categories. You know, you would have seen the reference to statutory deadlines, contractual deadlines, and so on. And so if the case was made out for urgency, the judges would hear it. And so Zoom hearings, I think, will continue to be the way of the future for some matters going forward, long after the effects of this COVID-19 pandemic has died down. It may not apply for everything. I mean, for instance, for cross-examination, you know, where you may want to assess the credibility and demeanor. There's obviously an elephant in the room in terms of, you know, the risk of witness coaching. I won't go into all that. You know, those are deeper points. But Zoom hearings, I think, will become the norm for a number of matters that involve, for instance, summonses, for instance, you know, where it doesn't involve examination of witnesses. So that's the second point. The third and last point is that I think the level of proactivity by our judiciary is impressive. And I'm, again, not saying this because I'm trying to flatter them. I don't need to. They're impressive enough as is. But what was impressive was our court vacation is typically in June. And they were, you know, very sensitized to the fact that lawyers, you know, were itching to get back to business, you know, to get back to hearings. Our circuit breaker phase ended on the 1st of June, or rather it's going to end on 1st of June, hasn't ended yet. And so ordinarily that meant court vacation. And so, you know, everyone will not have hearings, again, unless it's urgent or before a judicial commissioner, the judges would be on court vacation. But as an example of the solidarity of the judiciary with the bar and the aspirations of the bar, who were hoping to get back, you know, to their usual rhythm, there was actually a rethink, and the courts are open for business from 2nd of June onwards. So no court vacation for them in that sense for the month of June. And so those are three examples of how our judiciary has been nimble, forward-looking, proactive, able to use tech, and able to provide that access to justice in a way that satisfies the aspirations of both lawyer and litigant. I'll stop there.
Thanks, Gregory. I think that's very inspiring to hear. Again, it's also that collaborative spirit shining through between bar and bench. And also the idea that innovation is not just about technology, but it's also about innovation in terms of your process, your procedures. What are you willing to sort of allow in order to ensure that justice still gets served during this unique time? Perhaps we can move on to Attorney Domingo. In the Philippines, I'd like to really understand what's the impact been on courts. And you mentioned technology, and I'd be quite interested to hear how that has also been integrated, or, you know, to sort of address the situation. Sorry, Attorney Domingo, you're on mute. You need to unmute yourself. Thank you.
Thank you, Hannah. Just to back up a bit, many of the litigation lawyers in this country also were heavily impacted because, you know, they couldn't go to court. But many of the litigation lawyers also belong to big law firms, and you know, it's not that much to them. For the single practice lawyers, it has really affected their economic life, and that is why for some of our chapters we have emergency loans just to take care of them to weather the lockdowns. The other one is just like in Singapore, our judiciary has also been quick to to adopt measures like electronic filing, online discussions. But then let me just emphasize the reality, especially in our country, that even before COVID-19, there have been numerous proposals from the Philippine Bar, from the law firms and the stakeholders to harness technology to make our justice sector run faster and more efficiently. However, despite these early initiatives in law and in rules, not much has been done. And that's what perhaps the benefit from this pandemic, that the policymakers, the rule makers have finally awakened to the reality that we must really embrace technology. And the other one also is to a limited degree, because they've adopted changes in rules to address the current situation, the emergency situation. It has shown the policymakers and everyone that technology, online e-payments, online transactions, online meetings could actually make it easier and faster. So it works. But so now we hope that these things will persist beyond the pandemic, because I think that should be the new normal, because we've been yearning for that ideal situation and now we realize it can be done. But in our country, I don't know, perhaps it's not shared by Gregory and the lawyers of Malaysia, Steven. We know for a fact that our telcos are the slowest in the region, ASEAN region. And even if there are rules that allow or give us the opportunity to use online facilities for many of our transactions, and even in the justice sector, the infrastructure is not there. So that's a big constraint, and we hope that now that the government sees that it can actually be used, then we hope that there'll be more support for telcos, or even more pressure on the commercial telcos to deliver the speed, the reliability, and the security that's needed for us to make it a way of life in the legal profession in the justice sector.
Thank you so much, Atty. Domingo. I think, it is also very inspiring to hear that there are some positive outcomes that could come out from a crisis such as this. The urge and the drive to digitize that would have ongoing benefits for the long run. I mean, of course, it is contingent on infrastructure and whether or not the environment can support such drives. But if there is a concerted will, hopefully that would send the right message to the right people and to move things to get things done. Okay, finally, let's move on to Steven. When it comes to the courts in Malaysia, I'd be quite interested to hear how that has impacted the courts.
If I can just follow on from what you just said, Hannah, I mean, our courts have not been strangers to technology. I mean, we've had a number of things already in the pipeline where we were actually moving towards paperless hearings. All that were, as it were, almost at the onset of the COVID-19 outbreak. And we've got a e-filing system that has made a paperless filing a norm for many years. So all that were already in place. But we obviously had not moved up to the next step, which is the necessary step when facing something like this. And it didn't help that the courts were forced to shut down because the courts were also not listed as essential services under the regulations. And therefore, you had the courts not being able to take on physical hearings. That was the impact of it. But that didn't actually deter the courts. And again, kudos to our courts as well, because the judges were working. They were prepared to take on urgent interlocutory matters on an online basis. They were prepared to take on non-contentious matters where you don't need to turn up again in an online basis. And if I just may show you something, which is what the court actually provided, which is the disposal of cases that they were able to do as at 15th of April 2020. So what you have there, just in a quick sweep, are the three levels of our superior courts, the federal court, the court of appeal, and the high court, where they were able to handle as the matters as listed there. So it was not a case that the courts actually went to sleep. It's not a case that the courts actually were doing nothing over that period, and they were trying their best within the limitations of the law to handle cases that could be taken on. That was the initial, and then what happened was from the 26th of March onwards, which was just a matter of maybe 10 days or so after the movement control order was put in place, the courts informed the bar that they are going to move towards in a very aggressive way towards virtual hearings, and that we should be prepared for it. And then we had actually more matters now coming on as matters that could be dealt with and taken on a virtual hearing, provided parties could agree, and of course at the discretion of the courts. Now that proviso is important simply because we must appreciate the geographical challenges that we may have in a country like Malaysia. You'd have a broadband or a broad width challenges for lawyers. Not everybody could do virtual hearings. And then you had, because of the MCO, lawyers not being able to retrieve documents from the office. They couldn't go to the offices to retrieve documents. And in that sense, the courts were very fair. Where there was such an impediment, then those matters do not go on. Where the impediment is not there, then the courts move on. So you had those stats where matters could move on. And that is very early in the MCO. The courts were already moving. Not in full throttle as you'd like, but moving nevertheless. Then we had the courts actually come up with a demonstration as to how it intends to handle, in that case, an appellate matter in the Court of Appeal. And we were all given the benefit of that demonstration, and it was supposed to be done through Skype for Business as a platform, not necessarily the platform when it comes on. So you had that. Of course, what I mentioned just now, there was the natural pushback from lawyers who found it to be difficult for them to participate simply because of the concerns that they had. They were not really up to it in terms of the technological preparedness, I would say. So what they had to do is, and what they have to do is, because the courts have made it clear that virtual hearings are going to be a commonplace moving forward, we've all had to move up our game. We've had to up our game, as simple as that. And I think we can see the benefits of it, because many matters can be handled by virtual hearings. Not all matters can be. So that is a process that has been I think made apparent to us since the 18th of March. Now, just recently, and I'll flash this as well, without giving you the entire chapter and verse, as it were, of the proposed amendments, the courts have just come up for consultation broad-based amendments of our rules to provide for virtual hearings. So this is actually going to be in our rules, and that tells you the thinking that that's where we are moving, which is something that I think we were being prepared for, but now it's coming on probably fast and furious, and we need to be ready. Now, the last thing I want to say, and because a lot of things I've said, I think is repeated, it's been said by Greg and Domingo. I don't want to say those things, because our courts have been doing the same things as the courts have been doing in Philippines and Singapore. Health and safety measures in terms of appearance in court, because from the 13th of May, we could appear in courts under the conditional MCO. Physical appearance is allowed. But the courts have come up with a whole series of steps that must be taken. You have to wear a face mask as you go to court. Hearings are staggered. There are a limited number of persons who can be in court in terms of the hearing. For example, if you are counsel, you're alone in your matter unless you need a junior. You need to get permission for that. Your client is only there's only one person from your client is allowed to be represented. And as it happens in court, and I've not appeared yet, and I've been told, you actually submit with your face mask on, and the judges are face masked as well. You know, and you know, that is, as you can imagine, a serious problem for us. You know, because that's not easy if you're on your feet for an hour or so with a face mask on. But you know, that's the steps that a court have been put in place, because the courts have put in place because access to justice is important. The wheels of the administration of justice must move. It cannot be shut down by a virus, but that doesn't mean that the courts are going to be cavalier and things like this and just say we are ignoring health and safety concerns. So those concerns have been put, and we've all been told, for example, be well and early for court, because you know there may be a queue getting in before we actually process you and allow you to come in, including taking your temperature. All right. So it's a new norm. It's a new norm. But you know, we are lawyers. We are resilient. You know, and we'll get used to this, and we'll manage. Thanks.
Thank you, Stephen. I think the theme that's really coming out from this discussion in this section is that while technology is an enabler and the courts have been very quick and sensitive to adopt technology when necessary, it's not just a one-size-fits-all solution, and there is very much an assessment that goes on, a balancing act almost that goes on to make sure that you've got your health and safety concerns on one end, the needs of society on the other end, procedural justice, and how does that all tie in together to come up with the right type of innovation and technology adoption to ensure that justice is met. So thank you very much for that. I want to conflate the next two sessions because we've only got 15 minutes left. And that really is about protecting the most vulnerable and the impact on the rule of law overall. So while the virus was considered a great equalizer because it impacts, almost everyone is susceptible to falling sick, how a person might experience and come out of the whole ordeal really depends on their socioeconomic, environmental context. So wanted to understand from each of the panelists who were the most vulnerable during this pandemic, not just from a healthcare perspective, but from those who might have their rights infringed or who are the most legally vulnerable, so to speak. And how is this pandemic overall impacting the rule of law in our jurisdictions? So maybe Stephen, you can go first. And I think there is actually a question for the panelists on how has this impacted pro bono work. So I think this fits in very nicely with this last theme. So Stephen, please go ahead.
So when the movement control order was first put in place, the concerns were mainly for accused persons in remand, and that's where the court stepped up and they were able to still handle remand applications, and we dealt with that. And obviously, there's enough literature out there for the concerns of victims of domestic abuse in the confines of homes, and I think Greg alluded to that. But the current problem that we have is really the concern that we have is with our migrant workers and the way in which they have been treated. They have really been on the short end of the stick in terms of treatment under the COVID-19 outbreak. So in Malaysia, we have both, it's a complicated story. It's not as easy as something that you can compress in a few minutes, but let me put it this way. We have documented and undocumented migrant workers. I suspect that's the case in most jurisdictions. So in terms of documented migrant workers, the government initially took the position that they ought to be tested and the cost of testing would be borne by the government. Then there was a change to say that no, it's the employers who have employed these persons who will have to get them tested for COVID-19. Employers were up in arms saying that it's too costly and it's not something that we can handle, and that led to a lot of documented migrant workers being let off work using the COVID-19 excuse as something, but really they didn't want to spend the money. And that, you can imagine, that itself is a major social problem, that you have all the people out there that they have lost their sense of their income, they can't afford to get tested, and nobody is going to pay for their testing. So that's the first category you had. Then you had this undocumented migrant workers. And before anybody takes the high and mighty pony and starts to criticize these people, let me be very clear. Many of these undocumented migrant workers are because the system has allowed them to be undocumented. It has been convenient for the system to allow them to be undocumented. It's an inefficient system that has allowed this to happen. And they've been there. They've been part of our informal labor. They've been contributing to the economy. But now that we have this problem, there's such a pushback towards them. It's as if they are the source of the spread of COVID-19. And in the recent past, we have seen, in the past week or so, raids after raids into places where many of these migrant workers work, and they've been detained. They have been taken to detention centers. In terms of detention centers for these undocumented persons, the record shows, I think as of Thursday, last Tuesday, we have something like 4,342 of them have been detained. And the immediate problem, and many of the NGOs warned the authorities about this, that is not a clever thing to do. Putting these people in a confined place, in a detention center, you can't put them in prisons because prisons can be overcrowded. That they agreed. In detention centers like that would be a hotbed for the spread of the virus. And that in many ways has manifested itself, because in the past few days, except for yesterday when there was a drop, and if you go back the past 3 days, we've had a spike in terms of our cases after having gone down to double figures. it has went up again with triple figures. And where did the majority of this come from? Well, no prizes for guessing, the detention centers, and 3 detention centers. Of course, the authorities have wisened up since then. They are trying their best to isolate them. They are certainly being tested. They are certainly being provided with medical treatment. That's all there. But I think there was a massive mishandling of this problem to begin with, in the way it was approached. Example of COVID-19 being used as shelter for now removing your undocumented migrant workers, and then finding out that actually it's a problem. They all live in the kind of conditions we've heard about. You know, it's cramped conditions, it's not hygienic, you know, it is difficult conditions, and putting them in a detention center was in many ways a no-brainer in terms of, if you're going to prevent the spread, that's the last thing you should have done, right? So, you know, I'll leave it at that. So let the others have something to say as well.
Thank you, Steven. Actually, I think what really stood out to me is the confluence between strong legal systems, the rule of law, and public health. That's something that hasn't been really explored, and we don't have time in this panel to explore that, but I think there's definitely something there. Gregory, I'm very much interested to hear your perspective in the Singapore context, which is, you know, quite different because we're such a small country, very different social economic issues. So I'd be very interested to hear.
Yes, I think we have to remember that I think the challenges that Philippines and Malaysia face are, you know, of a very different magnitude because of the geographical distinction and the sheer size, you know. And so, in a sense, we are a tiny island state, and some of the things we can do, you know, can move at a certain speed because of that. I'll preface my comments on the questions of, you know, who are the most vulnerable by making a philosophical or ethical point first. I think the challenge when it comes to a pandemic like this, and it's a challenge that I think is for the bar leaders to apply their minds and to analyze, is to discern who are the vulnerable, who are the more vulnerable, and who are the most vulnerable. And because you have an evolving situation, people that may not be vulnerable at the onset of the crisis could become vulnerable as the crisis unfolds. And so you need to be very, very discerning throughout the course of this pandemic, which is why this is I can honestly say, is the biggest challenge that the bar leadership have had in maybe decades. You know, so every day there is a new challenge, a new problem, and, you know, trying to tackle things in terms of law firm expectations and so on. But coming back to the question of the vulnerable, you know, individuals or groups, I would say that you know, I would class the vulnerable into first what I would call vulnerable from a healthcare perspective. Steven has paid tribute to the frontliners, which I think all of us resonate and echo. But that is obviously, from a healthcare point of view, a group that we are concerned about. And so I was very, very glad that the CEO of LawSoc Pro Bono Services, fairly early stage of the matter, was already mooting how we could provide will services for that group on a gratis basis. And so that group is vulnerable. Then you have the elderly. And for that group, you remember the slide which I flashed earlier on about how we were able to advocate the position for essential and urgent services for the vulnerable. You know, and because wills are unique due to formalities of execution, which I think is very similar to Malaysia. I'm not sure about Philippines, but, you know, because of all those strict requirements, you can't work from home to do that. You need to have an office, and you need to be able to see the client and, you know, have the will executed according to the proper form. So that group, at least, you know, there was some access to justice through the recognition in the fourth category. So apart from the healthcare dimension, you also have those who are relationally vulnerable. And by that, I mean those who are potential victims of domestic violence. And you need to have access to justice for that group. You also have situations, and I alluded to this earlier, about tensions in the home on the rise. A UK study showed that 1 out of 8 relationships are on the rocks. 1 out of 8 relationships of those who are in current lockdown. That's a huge number, and it's a recipe for disaster, because you can imagine the simmering tensions if spouses who haven't spoken to each other in years, or a husband who has been out working and suddenly coming back to home and meeting a stranger, you know, the tensions are there. And that's why you have the phenomena in China and Japan of corona divorces, and we need to brace ourselves for how do we look after that group as well. So those are the relationally vulnerable. Then you have the economically vulnerable. And the economically vulnerable would be employees who have lost their job in this period. That's one group. Another group would be the businesses. And here, I'm going to share screen legislation, or rather the highlights of a legislation, which our government came up with. They moved at the speed of light in a parliament in terms of passing this through, but it showed a forward approach for various contracts, such as construction contracts, hire purchase, conditional sales agreements, events and tourism, and also leases. And I'm going to use the lease example to share screen for us, so that we get a flavor of what this legislation was. This is essentially, it's a highlight prepared by the Law Pro Bono Services team for the leases, licenses. It's a guide for non-residential property tenants who qualifies. Essentially, if you're a tenant of a non-residential lease and you entered into that lease before 25th March 2020, you can demonstrate that you're unable to pay that rent or charges from 1st February or later due to COVID-19. If there is a dispute over that, there is a panel of assessors that have been set up by the Ministry of Law, who will essentially incise into that matter. It's kind of quick justice. And so these are the parameters of what the Act doesn't apply to. What does the relief do? Your landlord cannot terminate your lease or evict you on the basis that you've not paid rent. Your landlord cannot start or continue court or insolvency proceedings against you. So you get a moratorium. You get a 6-month moratorium, which is potentially extendable to a year at the Ministry of Law's request later on. And it gives you that breathing space to negotiate with the landlord to try and restructure. It doesn't extinguish the debt. The rent continues to mount. Late payment fees mount, interest mounts, rent is not waived. Rent that has been paid cannot be clawed back. And if you terminate, you will still be liable for charges and other penalties under your lease. So it doesn't affect the substantive rights. But what it does do is that it nullifies the enforcement by granting the moratorium or suspension. And you fill up a form, and if the landlord doesn't agree, then you have that mechanism for the assessors. So I give this more as an example. There are similar types of regimes for the other types of contracts I mentioned. The last analysis of the vulnerable, the lost, the last, and the least in society are really the indigent. And for this, I'm very, 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 very glad that our pro bono team, headed by Tongi, were forward-looking to be able to offer online legal counseling to the indigents and to those that need access to justice in that setting. I personally am a volunteer, and about 2 weeks ago, I provided that pro bono virtual counseling. I could say honestly that that I didn't see any major distinction between that and in-person counseling. The person could see me, I could see them. Of course, they didn't know who I was, nor was I going to reveal. It's all meant to be anonymous, but I could take instructions, I could listen to that, and I could dispense the advice that's needed. In fact, I would say that interestingly enough, this online pro bono counseling could actually be even more facilitative for access to justice for some individuals that may find it uncomfortable to be in the same room as the lawyer and to pour out some personal details in person and to deal with the real-time dynamic because of the emotions that are involved. So interestingly enough, it could even be a boon. I'll stop there.
Thank you very much, Gregory. Okay, I'd like to turn to Atty. Domingo. Would you like to share your thoughts on protecting the most vulnerable in the Philippines and the impact on the rule of law in the Philippines? Sorry, you're on mute.
Thank you. Legal aid continues, and it's one of the hallmarks and the proud tradition of the Integrated Bar of the Philippines. And the Filipinos are very active in social media, and that is why our free legal aid now is at social media and mass media. It's much faster, much cheaper. It's accessible to everyone. So free legal aid has blossomed in a way. We have started this even before COVID-19, and now it has blossomed, and we intend to keep it that way. Legal aid online it's much faster, more accessible. Secondly, the prisoners, persons deprived of liberty are very vulnerable. We have been warning government about this. Historically, Philippine jails are so congested that it becomes cruel and inhuman punishment to be in jail. So it makes nugatory the constitutional right to bail, presumption of innocence, and the integrated bar and many sectors in the justice system have been complaining about this. Now, with this COVID-19 pandemic, the jails have become hotspots, and we're very thankful that the eyes of the Supreme Court, the judicial authorities, and Congress have been opened, and they've passed laws and amended rules to release tens of thousands of these low-level preventive detention prisoners. So we hope it will continue, and we make it a norm, not an exception, not just a reaction to COVID-19. Thirdly, which is very important, I'm very thankful that the point of view of Steven, the Malaysian Bar, there are so many overseas Filipino workers, migrant workers, and it is a special concern for the integrated bar of the Philippines, and we're focusing our activities and efforts on legal aid for these very vulnerable sectors. Many of them, hundreds of thousands, have been sent home. In other countries, they've been at the receiving end of restrictive controls and sometimes discrimination of labor. It's very unfortunate, but we would like to believe that the friendships we've made with the different bar associations, where there are significant numbers of Filipino migrant workers, will work, and we're very thankful. That's why IBP, under our leadership, has always been pushing for partnerships with different bar associations, because as Gregory has rightfully pointed out, it's a global phenomenon. It affects Filipinos all over the world. It affects different countries. We have to work together. Lastly, during these times of emergency, there's a tendency for government to concentrate power. And to my mind, the organized bar should provide a moderating effect, or even to advocate for a very healthy balance between police power and constitutional rights. Transparency, accountability, so far as the social amelioration program is concerned, corruption, transparency would be a very good way of preventing corruption. Organized bar, with our network, if we are heard and we are visible, then we can do a lot to help in nation building, even in this time of COVID-19, and insist that the best way of handling all of this emergency is really by the rule of law.
Thank you so much, Atty. Domingo. I think that was very inspiring, and I'm glad that we ended on a positive note and on the conversation of collaboration and working together. Unfortunately, we don't have time to take any questions because it was such an engaging discussion, but I would like to end off with just sort of the reminder that as lawyers, we do have a duty to uphold the rule of law, especially in times of disruption. And it's very encouraging to see leaders in the different legal communities really step up to try and support the entire legal fraternity in fulfilling this duty. So once again, I'd like to thank our distinguished speakers for taking the time to share with us. Once again, this recording will be made available. So if you have friends who want to hear and listen to what the bar leaders have been discussing, please let them know that they can access this on our website. So once again, thank you very much. And I'd like to wish everybody a good day. Bye-bye.
Thank you. Bye.
Have a good day, everyone.